Hello, everyone. I'm Brian Walker, and I'm thrilled to welcome you to Global Talent Immigration Law Group's special Valentine's live stream event, Love is in the Air. Today, Liz Profumo and Jordana Schwartz-Matricardi will guide us through the intricacies of marriage-based green cards. If you're navigating this journey or just curious, you're in the right place. Don't forget to like and subscribe to our YouTube channel for more insightful content like this. Let's dive into a conversation filled with love, law, and the path to residency. Welcome aboard.
Some questions first this time around. And if you have any questions, please feel free to ask them in the chat. Okay, so my first question is, what is a fiancé visa?
Okay, so a fiancé visa is a temporary visa that can be issued to the intended spouse of a U.S. citizen who plans to come to the U.S. to get married and apply for permanent residency.
Okay, that's pretty straightforward. Let's see, first question. What are the main reasons a fiancé visa could be denied, and how can we avoid these pitfalls?
Okay, so in order to be approved for a fiancé visa, the couple has to show that they've demonstrated, actually it's the foreign national who has to demonstrate that they've met their fiancé in person within the past 2 years, unless there are very special circumstances. So failure to demonstrate that requirement, it could be one reason, but in general, just being prepared for any consular interview is important, and making sure that you bring the right documentation and that you are prepared for what kinds of questions to expect and how to answer them. That's always important for any kind of visa interview. So certainly people that go in unprepared could also risk denial.
Okay. And what financial support evidence is required for the fiancé visa application?
Let's see. So actually for the fiancé visa application, there is not a financial requirement. The second after a fiancé enters the U.S. and marries their spouse, the spouse at that point has to file what's called an affidavit of support as part of the green card application. And in that phase of the process, the U.S. citizen does have to demonstrate financial support. So the level would be for a U.S. petitioner who is only supporting their spouse and doesn't have any dependents. The level of income they'd have to show would be approximately $24,000 US. And then it goes up for each household member if they have kids or other dependents in the household.
Okay, and if they are not able to meet the threshold, they have to find a joint sponsor, right?
Yes, if they don't meet the threshold through their income, they can either qualify through assets if they have sufficient assets, or through a joint sponsor.
Okay, great. All right, my next question. After arriving in the U.S., how soon must the marriage occur, and what is the process for notifying USCIS?
Oh, well, everyone knows this because of the show, the 90-day fiancé. So fiancés must get married within 90 days of entering the U.S. Thereafter, the couple has to file application for adjustment of status, and that's what actually is going to result in the green card.
Okay. And let me see if there's any questions in the chat. Okay, not yet. Next question. Can my fiance travel outside the U.S. after they arrive, but before we marry? And I guess they mean, can my non-citizen fiance travel?
Actually, that I don't know the answer to. I will have to look that up.
Okay. All right. Well, to be determined. How do we handle changes in our situation, like address or employment, between visa approval and marriage?
So after the visa is approved, then there's a gap, let's say, or a time when the application for adjustment of status is being prepared. So if there are changes before the application for adjustment of status is filed, then you just report those changes on the adjustment application. If the adjustment application is already filed, depending on what the change is, so if it's a change in address, you have to file a change of address with USCIS. Most other changes you wouldn't necessarily need to report until or unless USCIS either requests additional evidence from you or calls you for an interview.
All right. If the fiance visa expires before we marry, what are our options?
So I think what this is really getting at is what happens if you don't marry within the 90 days. And this is actually quite a complex answer, and it depends on where you live. So in certain jurisdictions, in certain states, mostly in the South, the foreign national is not able to stay in the US and process the green card, but instead they have to process it through a US embassy in their home country. They have to leave and process through the embassy in their home country. For if that happens in other states, so the circuits that require that apparently are the 5th Circuit and the 11th Circuit. Outside of those circuits, it's possible to apply for the adjustment, but it's still a risk factor and can cause issues. So the safest way to ensure the green card is issued is for the fiance to leave and process through the US embassy abroad, but that's quite onerous. So applying here is likely approvable, but there is a risk to that kind of application.
Yeah, it sounds like it. Okay. Well, I think that concludes our fiance visa questions for now. And I think we'll start talking a little bit about the marriage-based green card, which I think is on more people's minds, especially if they're currently here in the US on a visa. So first question is, how does the conditional status of a 2-year green card work, and how do we apply for permanent status?
So when a couple gets married, assuming they apply for the green card immediately after the marriage, they're going to be issued a conditional residency card, which is valid for 2 years. At the end of the 2-year period, they have to file another application showing they're still married and living together. And at that point, the government will what's called remove the conditions on the residency and issue a 10-year permanent residence card. Now, if a couple has already been married for more than 2 years at the time they apply, then actually they will get the 10-year card. They won't get a conditional card under those circumstances.
So they'll just get the green card straight up.
Right, but it's basically a safeguard to ensure that the couple actually remains married, and it wasn't just a very short-term arrangement just for the purpose of getting the green card.
Okay, that makes a lot of sense. All right, 2, can a spouse on a tourist visa adjust their status to a green card after marriage in the U.S.?
Good question. So yes, it is possible. Now, the complexity with that situation is that when someone enters as a visitor, in general, the government wants to see that they are planning to leave after a short stay and not that they're planning to stay here, get married, and stay permanently. So under those circumstances, the applicant has to be clear that their intention when they entered was that of a visitor or a tourist, and that after a certain amount of time, the circumstances changed, and that's when they decided to apply for the green card. So under those circumstances, it is possible to apply for the green card after you enter as a visitor.
Okay, and they should always wait 90 days before
Yes, there is a
applying.
presumption that if you enter and then you adjust status within, it used to be 30 days, there's a presumption that you've misrepresented your intention upon entry. So the presumption becomes rebuttable after 60 days. And then recently, it was at the consular level, it's extended to 90 days. So even though that is not technically adopted by USCIS, most practitioners will take the safe approach and wait the 90 days.
Okay. What are the implications of divorce or separation on a marriage-based green card?
Another great question. So it really depends on what stage of the process you're in. So if you have not been approved for permanent residency. So if the green card is still processing and the marriage breaks down, in that case, really the case should be withdrawn and you should stop the process if it's not approved. So now if it is already approved, then in that case, assuming you have to file that application to remove the conditions on residency, at that point, the foreign national will have to show that they entered into the marriage for the right reasons and not strictly for an immigration benefit, and explain how and why the marriage broke down and provide any documentation to show that the intention was valid at the time and what happened that led to the breakdown.
Okay. And what if the foreign national spouse wants to remain in the U.S., but for whatever reason they had to withdraw the application, or
Yeah, so if that happens, unfortunately, it leaves the foreign national spouse without any recourse unless they happen to have an underlying employment status or an underlying student status that they maintained throughout the green card process. So if that's the case, then they're allowed to stay based on whatever underlying status they held before filing the application. But if their status has expired or they don't have any underlying status, they don't have any recourse to stay. Only in very rare circumstances, but the vast majority of applicants would plan to depart the U.S. and apply. If they're going to apply for something else, they'd apply from abroad.
wow, okay. How can a non-U.S. citizen spouse obtain authorization to work in the U.S. during the green card application process?
Okay, so when a spouse applies for a green card, there are several applications that are filed simultaneously altogether. And one of them is a temporary work permit application. So that work permit should come through before the green card. Usually it'll come through about 3 to 6 months after the applications are filed. So it should, in theory, hold the applicant over until the green card's issued.
Okay. And what is the process for sponsoring a spouse who is currently living outside the U.S.? I think that kind of goes back to the fiancé visa.
The process is, there's similarities. It's not exactly the same, but when the spouse is living abroad, then everything is processed through the U.S. Embassy in the home country of the foreign spouse. And so first, the U.S. citizen files a petition here. After that's approved by USCIS, they forward the file to the National Visa Center, which is in the U.S. but part of the State Department. They will ask, at that point, a very involved application will have to be filed along with supporting documents. It'll take the National Visa Center a few months to approve that, and then they transfer the file to the U.S. Embassy in the foreign spouse's home country and arrange for the medical and the interview. So that whole process, we estimate, it really varies by country, but we estimate it'll take 15 to 18 months on average. Could be more, could be less.
Okay.
And, the follow-up question I always get when people ask about that is, well, so can the foreign spouse travel back and forth, and can they come visit me while that year and a half is going, that process is ongoing? And the answer is there's no legal bar that prevents it, but at the airport, the officers can see that this case is ongoing. So there's a risk if they think you're going to stay permanently. So you would definitely want to always have a ticket to depart and confirm they're not planning to stay until and unless the green card's approved in your home country, and have other documents that prove that you're planning to leave.
Okay. Looks like we have a question in the chat. Jane asks, how long does it take for the green card to be issued after you get married?
So just by getting married, the green card isn't necessarily issued just based on the marriage. After the marriage, the whole set of applications that I referred to earlier has to be completed and filed with USCIS. Thereafter, the work permit's issued, then the travel document, and then eventually the green card. So it depends where you live, how long it takes. Here in LA, we're seeing most of the cases go through in 9 to 12 months, although not all of them. Nationally, the published processing time is between 18 and 24 months.
Okay, well, that's a pretty big difference. What would cause a delay in processing?
I wish I could answer that. No one seems to know for certain. But what I am seeing is that any case that's not approved right away tends to linger for some reason and require some kind of intervention from, either the American Immigration Lawyers Association or Congress to get those cases unstuck and moving again. But I can't tell you what exactly triggers cases to be delayed. It seems like it can be any number of factors.
Yeah. Okay. And we have another question here from Maureen, and she's asking, can you repeat the process in case the spouse travels abroad? Can she do so after starting the green card and temporary work authorization process?
So if you are processing the green card through a U.S. embassy abroad, then you actually do not receive a temporary work and travel permit. So it's one or the other. Either you are processing through the U.S. embassy. If you have an underlying work visa, like an H-1B, an O-1, an L-1, then you can continue to use that visa to work and travel while the green card process is ongoing if you are processing through a U.S. embassy abroad. If you're in the U.S., you're not able to travel internationally, but you are able to apply for that work permit. So it's one or the other.
Okay. And this next question is actually pretty interesting because I feel like we were faced with this issue recently. How do we handle discrepancies in personal information like name changes during the application process?
So, well, discrepancies. So, if it's a discrepancy like a typographical or clerical error, then those are corrected with USCIS just through placing a service request. Now, if someone completes a name change during the process, so I strongly recommend that if you're going through a name change, that you actually wait until the name change is complete before you start the process, because the potentially converting all the documentation into a new name could definitely cause confusion and delays.
Yeah.
However, if it did happen, because things do happen, in that case, at some point, so if USCIS requests additional evidence or calls you for an interview, you notify them of the new name then and have all the supporting documents, which, is usually, I guess it would be a court order if it's not the marriage certificate, and you would report it then. And if you don't get an RFE and you don't go for an interview, then I suppose whatever document changed your name would hopefully also apply to your immigration documents for any legal paperwork that you'd need to do after.
Okay. I mean, I remember I had to go through all the name change stuff, after getting married, and it was a lot of work. So I can only imagine how much is involved in trying to do that. Plus, get your
All the immigration paperwork
process underway.
Yeah.
Okay.
I really try not to do it in the middle of the process if at all possible.
Yeah.
Yeah.
Okay. Let's see. Do we have any other questions here in the chat? Yes, we do. So Tiffany asks, do I have to be vaccinated in order to get a green card?
Oh,
Very
so
timely.
yeah, that is a new thing. So yes is the answer. Now there are people who are unable to be vaccinated. There is a waiver that you can apply for, that can be approved, that can exempt an applicant from the vaccination requirement. So if it's contraindicated, meaning that it is a risk to the applicant's health to have the vaccination, then the doctor who completes the medical exam will indicate that on the medical form. And at that point, No waiver is needed because the doctor has determined it's dangerous. Now, if the doctor says that it is not dangerous, but it is against your personal beliefs or your religious beliefs to be vaccinated, then there's a waiver that you have to apply for.
Okay. And do we have any idea of how often those get approved, denied?
I actually don't know. I don't know much. I have heard that they are granted pretty liberally,
Okay.
but I can't say that I have a lot of personal experience with it.
All right. And our next and also last question, I just want to make a call for questions. If anyone has anything they'd like to ask, please do so in the chat. Are there any special considerations for binational couples where one partner is transgender or non-binary?
So there's no distinction in this process. So whatever identity documents each spouse has are, submitted as part of the application, but there's nothing that's different for anyone who is transgendered or non-binary.
And I think the same goes for if it's a same-sex marriage,
Correct.
all the same.
That's right.
Yeah.
So there's no difference in the process. The requirements remain the same.
Okay. Well, that's all the questions we have. If there are any, other questions people would like to ask, please feel free to email us or you can get in touch with us through our website, and we'd be happy to have a consultation or answer any of those questions over email. Thank you.
Thank
you all for joining us today for Love is in the Air, our Valentine special live stream on marriage-based green cards. It's been a pleasure having Liz Profumo and Jordana Schwartz-Matricardi share their expertise with us. Remember, if you found this session valuable, please like this video and subscribe to Global Talent Immigration Law Group's YouTube channel for more updates and insights. Your journey doesn't have to be taken alone. We're here to help every step of the way. Until next time, take care and see you soon.